Bismillahirrahmanirrahim. Uh, Ladies and gentlemen, welcome once again to our course of Introduction to Business Law, especially students of the 5th semester in the Faculty of Business and Economics. In this session, we are going to look into the third part of our Introduction to Business Law, and third part discusses about the agency contract. First, we look into how we create an agency. As we understand that a person who has capacity to contract can enter into contract either by himself or through some other person. So if he adopts the first method, there is no question of agency. If he adopts the second method, then there is agency. The person who represents another in his dealing with third parties is called agent. And that person who is so represented by the agent is called a principal. What we have to understand is that according to the law of contract, which we covered in our first part, we say that a contract is entered into by two parties. That is the offerer and the offeree. So a person can decide to enter into a contract by himself without going through another person. But if you decide to go and enter into a contract through another person, then here we are creating what we call the issue of agency. And that's why we say that if you can enter into a contract by yourself, then it's okay. That one, you have directly entered into the contract and therefore no need of agency. But if you're going to enter into a contract through some other person or a third party, then here we have created the issue of what we call agency. And the person who represents another in his dealing with third parties is called an agent. And that person who is also represented by the agent is called the principal. So we have two parties or two people here that we are getting into our agency contract. We have an agent and we have a principal, meaning that the agent is a person who represents the principal. So the principal here, in other words, it means is the boss. So the following are the different modes of creation of agency. How do we create agency in business law? Agency is either created by express agreement, or agency by operation of law, or agency by ratification, or agency by implied authority. So agency by expression of agreement, here we say that a number of agency contracts come into force under this method. It may be either oral or documentary or through the power of an attorney. So this is the most widely used mode of creating agency in business law. Through this method, it is either by oral, one party or one person talks to another person. Either it can be verbal, or it can be documentary, or it can be through the power of an attorney. An attorney has the power, also can create agency between parties. So in such a manner whereby there is that mutual understanding of the need for creation of agency between the parties, then these two parties decide either it can be oral, through oral discussion, or it can be through documentary or through the power of an attorney to create what we call an agent and a principal, so that the agent will be representing the principal in all his major dealings. So one way we can create agency is by express agreement. Another way we can create agency is by operation of law. At times, contract of agency comes into operation by virtue of law. For example, according to Partnership Act, every partner is agent of the firm as well as other parties. So it is an implied agency. On account of such implied agency, only a partner can bind over firm as well as other partners to his activities. In the same way, Also, according to Companies Act, promoters are regarded as agents of the company. So by virtue of the operation of law, especially when it comes to if it is a partnership kind of a business where two or more people come together and then form a business, run a business together. So in such a situation, there is something we refer to as a partnership act. According to the Partnership Act, every partner of that particular business is automatically an agent. So here, the agency has been created by the virtue of the law that which operates the partnership business. The same also applies with the Companies Act. According to Companies Act, all promoters of a company are regarded as agents by virtue of the company law. So as a result of this, here you see agency has been created not by two parties coming together and say you are going to be the agent and you're going to be the principal. No, but by the fact that they are operating a business which automatically that business has a law that talks about agency issues, then it has been created. So agency can be created by operation of law. Another way an agency can be created is by ratification. Ratification means subsequent adoption of an activity. Soon after ratification, principal-agent relations will come into operation. The person who has done the activity will become agent, and the person who has given ratification will become the principal. So ratification can also be express ratification or implied ratification. So by ratification here means subsequent adoption of an activity. Somebody doing something without the other person's knowledge, then later on this other person comes to know about it, then the person gives a go ahead and supports that particular action. So by this way, it means that you have adopted an activity and therefore you have created the agency kind of a relationship. So the person who actually does the activity automatically becomes an agent, and the person who gives the ratification will become a principal. And when you talk about ratification, can be either express or implied. For example, in the case of express ratification, here adoption of activity is made by means of expression. Somebody will give his view, either it can be by word of mouth or by written or documentary. For example, without A's direction, B has purchased goods for the sake of A. Thereafter, A has given his support or adoption to B's activity. It is called ratification. Now, A is the principal and B is an agent. So for this case here, in this example here, as we can see, person A, without any direction, without giving any direction to person B just goes to the market and buys something for the sake of person A. Then thereafter, this person A gives support and say, oh, you bought for me this thing, it's okay, it's fine, I will pay for it. Gives his support or adoption to B's activity. This is what we call ratification, and he has supported this by mode of expression, either by written or it can be by oral expression. So by ratification or express ratification, it is where the adoption or the support of somebody else's activity is done either by word of mouth or by written form. Ratification also can be implied. The ratification where there is no expression is called implied ratification. For example, Mr. Q has P's money with him. Without P's direction, Q has lent that money to R. Thereafter, R has paid interest directly to P. Without any debate, P has taken that amount from R. It implies that P has given his support to Q's activity. This is what we call implied ratification. As you can see in our example here, we have two people, that is Mr. Q and Mr. P. Mr. Q has money belonging to Mr. P, And this Mr. Q decides to take that money. That money is not his, it belongs to P, but he takes that money and gives to another person, Mr. R. Then Mr. R pays back that money with interest directly, not to Q, but directly to P. So here, then this person P, because it is his money, he takes that money without any debate, without any discussion, and keeps that money. So it implies that P has given his support to Q's activity. As you can see, when R was giving this money to P, maybe this person Q was not around, and there was no any discussion between P and Q. So he just took the money and kept that money. So as a result, it means that he has given what we call an implied ratification. Created agency here by no expression, no any word of mouth between P and Q, or nowhere written agreement between P and Q of creating an agency contract. So this is also another mode that which agency can be created through ratification, which we refer to as implied ratification. Another mode that which agency can be created is by implied authority. This type of agency comes into force by virtue of relationship between parties or by conduct of parties. For example, A and B are brothers. A has got settled in foreign country. Without any request from A, B has handed over A's agricultural land on this basis to a farmer, and B is collecting and remitting the amount of rent to A. Here automatically A becomes principal and B becomes his agent. In this example here, two people are brothers, and one of the brothers goes abroad to another country, lives in another country. Now that other brother who remained in the homeland decides to take the land belonging to the other brother who is abroad and gives it or rents it to another person to do agricultural activity. And every month, that person who rents that money gives that money to B, and B sends that money to A abroad. So here you can see that actually agency has been created by the virtue of the relationship between A and B. They are brothers. So because of that kind of a relationship, brotherly relationship, this person B decided to give out his land to another person. As a result of that, agency has been created, and A becomes the principal and B becomes his agent. Agency by implied authority is of three types: agency by necessity, agency by estoppel, and agency by holding out. When we talk about agency by necessity, at times it becomes necessary to a person to act as agent to the other. By necessity, for example, A has handed over 100 quintals of butter for transportation to a road transportation company. Actually, it is a bailment contract. Assume that in the transit, all vehicles has got stopped, where it takes 1 week for further movement. So the transport company authorities have sold away the butter in those nearby villages. Here, agency by necessity can be seen. This is a very good example here. One person goes to a transportation company with 100 quintals of butter. As you know, butter, it is a commodity which actually expires as quickly as possible. It is a perishable good. Now, during transportation, when the products were being transported from one place or from one town to another town, it came to a point whereby there was some interruptions on the way, and the bus or the vehicle which was transporting this butter could not be able to reach the final destination at the right time. So it meant that by the time of 1 week, you cannot stay with butter for 1 week. Automatically it will expire, it will go bad, and you will make losses. So the transportation company decided to sell this butter to the nearby villages because the car could not move. Take an example, maybe you are you are transporting butter from Bur'o to Hargeisa. In the middle of the way, reaching the Abrug, you find there is a lot of water on the road, and the car or the bus cannot actually pass through, and the water seems to be too much. At this particular moment, the transportation company can decide to sell that butter, that which it was transporting to Hargeisa, to the nearby villages of the Abrug. Why? Because if they could continue staying with that butter in their car, automatically it will expire, it will go bad, because it is a perishable good. So as at this moment here, you can see agency has been created by necessity. It is necessary. It has become necessary actually for a person to act as an agent to the other person. So by necessity is one way of implied agency created by implied authority. Another one we have is by estoppel. In presence of A, B says to C that he is A's agent, though it is not so actually. A has not restricted B from making such statement. Here, agency by estoppel can be seen. By estoppel, it means somebody making a claim that actually I am an agent of the other person in front of a third party. Then the other person, without any argument, he confirms and he says, yes, he's my agent. Okay? So as you can see here, in the presence that all the three people are there, all the three parties are there, but one person decides to create agency with another person, so that to convince the third party that actually I am working for this person as an agent. And without any restriction, as you can see here, A has not restricted B from making such statement. Does not even say, no, you're not my agent. Does not make any argument. Here, agency has been created by means of estoppel. Another way we can create agency is by holding out. B is A's servant, and A has made B accustomed to bring good on credit from C. On one occasion, A has given amounts to B to bring goods from C on cash basis. B has misappropriated that amount and has brought goods on credit as usually. Here is agency by holding out, and therefore A is liable to pay amount to C. Another good example we have here is between person B and person A and person B. Person B is a servant, is a worker in the house of person A. Take an example in your house, for example. Maybe you send your maid to go and collect food from the shop every day in the morning, go to the shop and get some goods on the basis of credit. And then end of the month, you pay that particular amount. But one particular day, you decide to send your maid to the shop not to take goods on credit, but by cash. You give her the cash and tell her, go to the shop, collect for me those goods from the shop by cash. But this maid goes to the shop because he's used to getting the goods on credit, decides not to pay the cash and gets the goods on credit. Here you can see person A, you, the owner of the house, who is normally sending the maid to the shop, you are liable to pay that particular amount of money to C, to the shop. Here, agency has been created by holding out. So agency can be created through several means. According to our lecture here, we have seen four major modes of creating agency, either by express agreement, or by operation of law, or by ratification, or by implied authority. Termination of agency contract. As we understand, agency contract sometimes cannot stay forever. There must come a time when actually it has to be terminated. So termination of agency may take place in two ways, either by the operation of law or by the act of parties. By the operation of law, an agency contract can be terminated by expiry of time. So when the time, maybe sometimes you have signed a contract with your agent, somebody to act for you as an agent in a period of 2 years. When the 2 years come to an end, automatically that agency contract is terminated. At times, contract of agency may get formed for a particular period. In such a case, after expiry of that agreed period, termination of agency takes place. Another way that an agency can be terminated is by fulfillment of object. At times, the contract of agency may be formed for a particular objective or to do a particular venture. In such a case, termination of agency takes place after completion of that venture. After you have fulfilled your objective, maybe you have formed the agency in order to do something and reach a particular objective. Once you reach your objective has been achieved, then that agency contract can be terminated. Another way that it can be terminated is by death or lunacy of either party. Whenever principal or an agent comes across death or lunacy, agency contract gets terminated. If somebody dies, automatically all his deeds here on earth comes to an end. Meaning that if one was your agent or you are your principal, and maybe he or she has died or has become a lunatic, has lost his mind, cannot be able to differentiate between what is right and what is wrong, then at this particular moment, the agency contract can be terminated. Another mode is by insolvency of principal. The principal should have the capacity to contract. When the principal becomes insolvent, he foregoes capacity to contract and termination of agency takes place. But the Act is silent with regard to insolvency of agent. As minor also can act as agent, it can be confirmed that insolvent persons may act as agent. With regards to insolvency, as we understand according to the rule of contract, that is the capacity of parties, a person who is entering into a contract should not be an insolvent. An insolvent is incapacitated, is not allowed to enter into a contract. So if the principal becomes insolvent, automatically he or she will stop being a partner to a particular contract. So in such a case, the agency contract can be terminated. However, when it comes to the issue of an agent, there is no law that actually talks about an agent when he becomes an insolvent can actually cease being part of a contract. No, because even an agent can be a minor. A minor, as we saw last time when we were learning about capacity of parties, we looked about an agent as a minor as a part of a contract, and we said that a minor can act as an agent. Also, an insolvent person can act as an agent. So meaning that if the agent is insolvent, no problem, the contract can proceed. But if the principal becomes insolvent, here automatically this particular agency contract has to be stopped. It cannot proceed. Another way that which agency contract can be terminated is by destruction of subject matter. When subject matter of contract gets distracted, agency contract comes to an end. Also, the principal alien enemy. When principal is an alien and war breaks out between the countries, then principal becomes alien enemy and agency contract gets terminated. Yes, as we had looked previously also during capacity of parties, we talked about an alien. An alien is a person who is a national from another country but has acquired nationality in another country, meaning that this person has what we call double nationality. So an alien, not being a citizen of that particular country, a true citizen of that particular country. So if the principal and the principal becomes an alien, and then the war breaks out between his former country and the current country where he is in, then automatically it means that all contracts that which this person actually is in becomes what we call void. And therefore, the same applies to the agency contract. He automatically will stop being a principal and this contract will actually be terminated. Liquidation of a company on account of legal entity. Company may act either as a principal or an agent. Whatever the status may be, If the company enters into liquidation, that is the selling of company assets to pay debt, then termination of agency takes place, because now the company will not be having any more capacity to act either as a principal or as an agent. So automatically it has to be terminated. Also, termination of sub-agency. Whenever the main agency gets terminated on account of any reason, then sub-agency also goes off. Maybe you have your big company and you're having some sub-agents around the country. When the main company becomes off or gets terminated on account of any reason, then also those other sub-agents, the small agents which were representing the main agent, will also be terminated. So with regards to the termination of agency contract, according to the operation of law, those are the ways that which actually can lead to the end or termination of a contract. Then finally, we have termination of agency by act of parties. The parties that have entered into the agency contract, their actions can also lead to the termination of an agency contract. And the following situations are when the agency is terminated by act of parties. First is termination of agency by the principal himself. The principal can terminate the contract of agency by giving notice to agent. By doing so, if agent comes across any suffering, the principal has to compensate the agent. So the principal can decide to terminate the contract. And if you are doing so, you have to communicate to the agent. And in case the agent comes across any suffering, then you, the principal, have to pay for the compensation. Also, termination of agency by the agent. The agent also can terminate the agency contract by giving notice to principal, but by doing so, if the principal comes across any suffering, agent has to compensate. The same also with an agent can actually decide to terminate a contract. And if an agent terminates a contract, then you have to give notice, inform the principal. And in case the principal comes across any suffering as a result of this termination, then automatically the agent will have to pay for the compensation. Also, termination can be done by both parties. Both parties, that's by means of mutual understanding between the principal and the agent. The contract of agency may come to an end. Both of them can discuss and say, we cannot proceed with this contract, and therefore let us terminate, let us cancel everything, and therefore they can decide to cancel whatever they have actually formulated. What are the rights and duties of an agent? Remember, an agent is the person representing the principal in his dealings. It's just a representative. So this representative, regarded as an agent, has some rights. The first right is right of retainer. Agent has right to deduct the amount which is due to him by the principal from amount payable to the principal. Yeah. So the agent has the right. You can deduct the money that which you demand the principal, basing on the amount which is payable to the principal. Maybe if you are representing the agent in you're presenting your principal in selling products A. Maybe product A costs $5, and you have agreed upon with the agent, with the principal, that every product you sell, you will take $1. So meaning that after selling this product, you as an agent, you have a right to deduct or to take away your share from that $5, which means that the $1 you have to get it from $5 and only give the principal $4. So there it means that you are practicing or you're exercising your right of retainer. That means that deducting the amount which actually is due to you by the principal. Another right is right of stoppage in transit. In case where agent is personally liable, he has right to stop the goods in transit. The good may be moving towards the customer or towards the principal. Also, as an agent, he or she has the right to stop the goods whenever they are moving. Maybe the goods are moving from the principal to the customer, or from the customer to the principal. In between there, the agent has the power to actually stop those goods from moving from one point or one person to another person. Another right is the right to claim remuneration. As per the terms of agency contract, agent has the right to claim for remuneration. Yes, you have to be paid for your activities as an agent. So meaning that the principal has to make sure that the agent is remunerated at all times as per the terms of their agreement. So in case it is not done so, then the agent has the right to claim for that remuneration. You can go to your boss and tell him, hey boss, you're supposed to remunerate me, give me this amount of money that we agreed upon, and the boss will be able to actually remunerate you or give it to you. Another right is the right of indemnity. Principle of indemnity, that is the protection, gets operated between the principal and the agent, where the principal is implied indemnifier and agent is implied indemnity holder. So the agent can make the principal answerable for all types of suffering because he is protected according to the principle of indemnity. The agent is just a representative of a principal, and he is regarded as just an implied indemnifier. And the principal here, the principal is implied indemnifier and the agent is the implied indemnity holder. So meaning that the agent is highly protected according to the what? To the principle of indemnity. And therefore it means that in case of any suffering, the person who will be held responsible is actually the principal. Another right is the right of lien. Agent can exercise right of lien, as we had seen in our previous session. That is, lien, it's all about keeping the properties of people that owe them money, so that until the money is paid. So an agent can exercise the right of lien. However, Contract Act has not specified whether it is general lien or a particular lien. Therefore, the nature of the agent's lien depends upon mutual understanding between the principal and the agent. So those are some of the rights at which an agent has in his operations. Among the duties of an agent should follow the instructions given by the principal at all time. If agent comes across any complicated situation, he has to communicate that situation to principal and his advice is to be obtained. Agent should behave in his capacity as an agent. He should not run the transaction in his own name. Remember, you are representing your principal, so you have to just act as an agent and not again trying to masquerade around as a principal. Also, an agent should not make secret profits. So the agent should not make secret profits by utilizing a reputation of the principal. Make sure that you do everything openly, and in case of any profits, you have to actually communicate it directly to the principal. Also, the agent should safeguard property of the principal, particularly upon happening of events like death of principal or insolvency of principal and many other things. So you as an agent, you're supposed to protect the property of the principal at all costs, and don't be a person who is actually going to secretly steal the properties of the principal in case of happenings like death or insolvency. Also, the agent should maintain proper accounting records to enroll the transactions run by him. An agent has to remit amounts to principal properly without hiding any information. And finally, an agent should not carry on delegation. So that brings us to the end of part 3, which actually discusses about the agency contract, where we have specifically said that in case a person decides to be represented by another in a contract, then it automatically means the issue of agency has been formed. And we say that agency can be formed either by means of express agreement, or by the operation of law, by ratification, or by implied authority. That brings us to the end, and if you have any question, you can drop them through my WhatsApp number 063-427-1957. Thank you very much, and wishing you all the best.